the police persons who are not uniformed and carrying military-style guns, actually assault rifles, not uniformed, carrying assault rifles, not wearing any protective gear, okay, to face demonstrators or a mob or a rioting mob. What would be the intention of such deployment if not to kill the mob? I hope you get me. That you are not uniformed, which means nobody can organize as a police officer. You are not having any protective gear, which means don't fear. You are not scared of any possible assault. And you are deployed into a crowd, which is charged. Okay? Finally, is, and I posed this question yesterday to IPOA, and they agreed that indeed it is possible for a private entity or person to undertake private prosecution. And this is clear, it's implicit under Article 157 of the Constitution. 157.6, the director of the DPP, rather, shall exercise state powers of prosecution and may, among other things, at B, take over and continue any criminal proceedings commenced in any court that have been instituted or undertaken by another person or authority, and so on and so forth. Of course, this implies that another person or authority other than the DPP can institute private prosecution. Because the case we faced yesterday was that the IPOA has forwarded numerous files against specific police officers whom they accuse of killing Kenyans during demonstrations, and yet those files are still lying at the DPP. Nobody knows what became of them, and nobody for sure knows when they shall ever be released or be acted upon. Is it possible that Amnesty International and related organizations or persons can exercise the right under the Constitution and the law to institute private prosecution against these culpable police officers? Thank you. I'll stop it at that.
Maybe just to say something, my name is Catherine. The demonstrators, as much as they have the right to demonstrate, let them keep off from school zones and know that the children have their right. That's what I wanted to say.
Yes.
Just the demonstrators or the police, because police also tear gassed innocent kids in school, in Westlands actually.
Yeah. That's a very valid point.
Very, very specific.
Let us keep
the demonstrators.
Police off school areas. Demonstrators also must keep off school areas.
Thank you, Bwana Irungu Newton, with your Amnesty International, and we thank you for the good work you're doing. At times, I like us to speak for posterity, because Hassan Omar was chair of the Human Rights Commission. At the same time, I was chair of LSK. And when you speak for human rights, it's always good to speak that you would be on this other side. And I remember one time Ahmed Nasir told us, as a Muslim, Islam dislikes people are dishonest, people are deceptive, people who tell lies. They like honest. So I'm sure all of us here want to have an honest discourse. The point I've picked, which I think is a problem, you have said that there's a problem in prosecuting police officers who engage in police brutality and in violence against innocent people, including, I hope, these two innocent kids who were killed in the hands of police. And we need to get a solution because we need accountability. What we are discussing here is about governance. We need accountability. Now that it seems the police will always be out there to shield their own, would you maybe propose that we need to look for another different legal mechanism? Because it seems from the report you have given us, it seems the police will never prosecute their own. And that's what Ipoa told us yesterday. In the US, they have what they call an independent counsel. If you want to prosecute somebody in Congress, you will get an independent counsel. The Attorney General will propose, the High Court will confirm the appointment, then an independent counsel will go and investigate maybe a congressperson or a sitting president or somebody high level in government, knowing that, today that side will be in government, tomorrow they may not. In Zambia, you saw what Lungu did to Echilemi Akainde. This week, Echilemi Akainde is telling Lungu, these jokes you do on Saturday, that is politics, I'll come after you. This keep changing. Now Echilemi Akainde is telling Lungu, don't joke. In last elections, supporters of Echilemi Akainde were tear gassed. One guy was shot outside a police station. So we want to do this for posterity. Would you support a proposal that we create an office of independent counsel so that if there is an allegation, even today it could be me, tomorrow it could be Honorable Mbarire, of police brutality, we don't leave it to be in the hands of the police, but we get somebody independent to do the investigation and prosecution so that we bring an end to what you call impunity within the police force. I just wanted to get your take on that particular issue. Thank you.
Thank you, Senator. Maybe, Mr. Irungu, let me begin by associating myself largely with the sentiments of Senator Omar regarding the deployment of officers in Haiti, because that's a matter that's really not in the realm of this committee, and we need to exercise caution, as Senator Omar said, so that we don't put our men and women in uniform in harm's way wherever they serve us, because they are all our children, they are Kenyans like ourselves, and we owe them that duty of care in whatever we say. But you appreciate, Houston, there is also a very thin line between protecting the rights of demonstrators, and in that case, demonstrators who are not doing so peaceably and unarmed, as is stipulated in our Constitution and our laws, and also the duty by policemen to protect life and property of those who are not otherwise involved in violent protests. I want to believe part of the reason we are here as a dialogue committee, as His Excellency keeps reminding us, is so that we are able to dialogue as a country, to put behind our nation the culture of violence, and where we settle political disagreements using violence. And from where you sit as human rights crusaders and activists, you then owe the country a duty of civic education. That, and I have seen players in the civil society demonstrate over the cost of living peaceably and unarmed, not with machetes, not with stones, and they do so, and the police actually escort them, even to the gates of Parliament. I have seen them even chain themselves to the gates of Parliament, peaceably. I don't know what your role would be as a civil society players and more so human rights activists to protect the rights of even officers and other Kenyans who are not involved in the violence. And probably also engage Kenyans in a crusade of civic education, where you educate Kenyans that a demonstration, a procession, a protest, picketing does not necessarily mean a campaign of violence and anarchy. Because when we get into a campaign of violence and anarchy, then you leave the police in a catch-22 position, where police officers have to protect another Kenyan's supermarket being looted, and the people looting have machetes, are armed with stones, they have broken into a supermarket, you lobby tear gas, they do not respond, they continue looting and threaten the police. Therefore, there has to be that balance, and we must appreciate that balance. Two, nobody in this country would advocate for excessive use of force, because as Senator Mugeni says, today it's Opio and I, tomorrow it's me. And trust me, I have been there, I know. Those two young Indians you refer to and their taxi driver are people I knew, are people I worked with. There was no reason, absolutely no reason for those young Indians and the Kenyans who were killed by the people, as you say, who are known. Therefore, as we speak about Kenyans who were killed in the demonstrations, let us not forget those Kenyans who were executed in the name of politics. Those young Indians were executed in the name of politics for no reason at all. And not just those because of Kenya Kwanza. There are many Kenyans. And Irungu, you remember the bodies that were fished out of River Yala, simply because of their political beliefs. People we knew. Therefore, as we speak, and I speak this with a very heavy heart, because we lost so many people that worked with us in the last campaign because of what they believed in politically. And we had their bodies in River Yala, some in River Tana, others in the Abadeas. Those young Indians, you have rightly said, the officers are known, but they cannot be prosecuted because the bodies have never been found. But therein brings me to my question, Mr. Irungu and your colleagues in the human rights world. Tomorrow, and Omar Hassan also did point out to the incident where they were advocating for the rights of people who are being accused of financing or engaging in terrorism. And you have a duty to defend their rights. Tomorrow, I am almost certain, if those officers were charged in court, of course, the lawyers in the room will rush to represent them. But also human rights crusaders will be there speaking about their rights, knowing very well that these are the people who participated in these extrajudicial killings. You've also spoken about the right of passage, and I agree with you wholly. The right of passage, especially of medical personnel, of journalists when during demonstrations. You've spoken about the police lobbing tear gas in schools, in hospitals, but you're also aware there were incidents where youth, again, were getting tear gas canisters lobbed at them to disperse them. They get hold of the tear gas canisters and hurl them back in private institutions, in schools, in hospitals, to create a situation of anarchy. Therefore, maybe I don't know what you would do, and I have no solution myself as to what you would do as human rights crusaders to ensure that when people claim to be peaceably and unarmed to be demonstrating, then they also do so in designated places. Your rights end where mine begin. It is so said. Why would anyone stop another Kenyan from going to work because they want to protest? Why don't we have a country where we are decent, where we are civilized, that if we're having a demonstration, on the cost of living. We do not have to pull down the entire infrastructure on the expressway in the name of protesting. That we can peaceably and unarmed gather at a designated point, protest, and say all the manner of things we want to say against whoever we want to say against. Then peaceably go home in the evening. And I don't know, I have no solution, it's just probably more of comments. I don't know if there's anyone else with something else before we close. Maybe if not, we can close at that and Nirungu can answer those ones.
Thank you very much. And I now know why I was looking forward to this engagement, because the questions have been clear and direct, and I thank you all for the frankness and the courteous way that you have responded to our presentation. The points that have been raised fall into 7. Allow me just to quickly deal with them. Haiti, and I will exercise I will exercise a bit of judiciousness in terms of response based on Honorable Hassan's comment. The issue of data and verifiable data. Thirdly, the issue of policing approaches during assembly, private prosecution, legal reform, civic education, and criminalizing disappearances. And I'll try and be propositional on all of those issues. Allow me, first of all, just say, Your Excellency, thank you for the kind words at the beginning. May God and government keep me safe, keep Amnesty safe, keep all human rights organizations safe, and indeed all of you, and 50 million Kenyans. I mean, that is the spirit, I think, that our constitution is drafted. On the issue of Haiti, and it is a weighty matter, allow me just to say 2 or 3 things as the process begins to unfold. And of course, one is the UN Security Council, and the second is our own very own National Assembly. As Amnesty International, we believe that there has to be clear and mandatory enforceable parameters for the mission. What those will take is obviously a matter of experts. We need to make sure that there will be no excessive force, there will be no corruption, and secondly, there will be no sexist exploitation. The people of Haiti have, as we know, suffered too much. They require a human rights-based policing mission. And I believe that with these procedures, these parameters, and as Amnesty, we can offer any of the authorities ideas on this within a UN framework, it can be done. The second recommendation on Haiti is that there has to be a UN oversight mechanism that ensures that Haitians have access to issues of accountability, to access to justice and redress where there may be excesses. And I think this would be very important. We would also say, given our own experience, that we would invite the National Assembly to ensure and require that all commanders, not just the topmost commander, of whom we have respect as Amnesty International, that all commanders are assessed on the basis of their ability to de-escalate situations. Let me turn to the second part of the second question, which relates to the data. There will be some difference in data, Honourable Omageni. I think it is very difficult, as many people know, to be able to have one verified source on a moment as intense as the demonstrations that we had. Our data is verified. We can say behind every one of those statistics that we have verified those numbers, and I believe the IPOA, who came before you yesterday, could probably do the same thing. We would probably, respond to some of the questions that are raised around the what broke down in terms of policing over this period. And it is gratifying, I guess, for the co-chair, Honourable Kimani, who says that nobody will challenge the constitutional principle. Allow us to also say that we respect the uniform. We respect the oath of office that police undertake, and most of the 100,000 police officers are not going to be held liable for the violence that we saw over the last 6 months. But I think there are a number of things we need to point out. On the basis of our own research, what we realized is that the crisis started at the point that the police refused to accept notifications, that they began to intimidate and arrest organizers, and wherever protesters gathered non-violently, they dispersed them with tear gas, rubber bullets, and as the months continued, live weapons. There was a point, I don't know if you recall, in July when it was actually very difficult to be able to distinguish between bystanders, marshals, protest organizers, uniformed police officers, non-uniformed police officers using military-grade weaponry, looters, criminals. And the question we have to ask ourselves is, based on that experience and in the knowledge that we are a troubled nation economically, and that even if the political class can find a way of setting aside the differences and setting aside the grievances from the past, we are still a troubled nation. There will still be protests and demonstrations. So this is why we say, as Amnesty, it is important that we have a serious national policy review of how we police assemblies. And our recommendation is essentially a national policing conference. And it has helped break through a number of problems that we've seen. Allow me to turn to the recommendation or the suggestion, and I smiled a little bit as the presentations went on because we thought we were coming to task the committee, but we have received a few tasks on our side, which we gladly pick up. The first is that the Constitution is innocent. The Constitution is the one instrument or the one person that will not be dragged through a court of law as a result of the violence that we've seen in the last 6 months. We would probably argue that the laws are also innocent, with the exception of possibly one. Because we feel that the National Coroner Service Act, which was passed by the National Assembly 5 years ago, gives us the capacity for an independent forensic capacity, for legal capacity, for a operational capacity to hold police officers accountable, to be able to independently assess crimes committed by uniformed officers. And therefore, we probably would not, at this stage, but again, perhaps I can speak with the former Law Society of Kenya chairperson to see how this independent tribunal might be constructed. We would simply say that you have the laws in place. Can we implement them? I think the second area really is to reflect a little bit on the Public Order Act. And I think this is the one area where Honorable Hassan will probably also agree with us in addition to the other things that he has said this morning, which is we have an archaic Public Order Act. It is so far behind the Constitution that it is out of focus. We would call for its immediate repeal and replacement with clarity, clear legal provisions that do not offend or criminalize protesters, but keep protests lawful and non-violent. And I think, Honorable Kimani, let me just turn to your point, which I think is really important. You know, we spoke to a number of prosecutors and police officers, and many of them requested anonymity, which was a matter of concern for me, because in many ways what we are discussing are national issues. They should be matters that we can debate and take responsibility for our comments. But one of the things that, you know, we came away from those conversations was that there is a difference between protesters who destroy property, who assault others, who rape and sexually molest others during these moments of turmoil, and protesters. And the problem is that we are not able, and I say we, I think as an ecosystem, we're not able to distinguish between those categories that I read out earlier. The bystander, the marshal, the uniformed officer, the looter, the criminal, the protester, and the non-uniformed military officer that is not carrying any identification, but is carrying military-grade weapons. And I think what we have to do is we have to begin to distinguish that much more clearly. None of the policing that we saw during this period that we documented had the capacity to distinguish this. In fact, it was almost blurred to a point that we began to think it was deliberate. Because if notifications had been given to protesters from the political parties, if the protesters had been facilitated, given assurance, there had been clarity in terms of the routes of the demonstrations, and there had been recourse when criminals come to hijack those protests, I have a feeling that we would not have de-escalated or rather spiraled in the way that we did. And therefore, I think there is an opportunity going forward now that our heads are clearer and the violence has hopefully is behind us for us to be able to do this. Let me lastly turn, I think, to the point that's been raised in terms of civic education and private prosecution. 80% of Amnesty's work is civic education. We spend a lot of time in our schools with young people. We spend a lot of time with families that have, have experienced human rights violations. And to be honest, that is the best part of our work. It actually pains me to come before the nation with those statements, those press conferences, even to discuss like this, the ugliness that our country is capable of. So I would really look forward to the committee looking at this issue of civic education. For the record, we pushed very hard just before the last elections with the Jubilee administration. And the Jubilee administration, through a note verbal, banned funding by the donor community to the IEBC or to civic organizations to do civic election work. And we said that the most dangerous thing is an election where you have high levels of disinformation, misinformation, a lack of regulation of social media platforms, and algorithms that nobody understands how they work, except the people who pay for them. As we move into a season of artificial intelligence, I know I'm moving slightly far. I think we have to look at the quality of civic education that is available for our people. We are in the moment of a moral hysteria around LGBTIQ persons. Allow me to go there also. There are individuals and constituencies that are deliberately trying to whip up homophobic and hateful comment against people that have committed no law and have not been taken to a court of law. But they would rather that they are beaten, that they are stripped, that they are taken from their homes and their jobs. But let me not stop there for those of you who haven't got quite to the position of care and compassion. We have to think about that baby, that 3-year-old child called Brighton Sagini. And it still burns me, that story. How does a 3-year-old be killed by 3 generations of her family? A grandmother, an uncle, and a cousin. 3 generations conspired to kill a child 15 years before that child had any opportunity to inherit that land. Or perhaps we can go to Shakahola and discuss how is it possible that close to 500 people could have been persuaded by one very charismatic evangelist to kill themselves through starvation. Allow me just to end on a sober note. Our country is ailing. And we must provide the leadership at this time for the country to become respectful of diversity, to be anti-discriminatory in its nature, or we will continue to see violence perpetuated when we have a solid constitution. I have not talked about gender, and I can see Cecilia is asking me, what about misogyny and sexism? The level of intimate spousal abuse in this country is unacceptable, and we are not doing enough about it. So let me just concur with the idea that civic education is where we need to go, and hopefully, as Amnesty and all the other organizations, we will be allowed to continue doing that work, because I think it is really what will save us in the long run. Let me very directly invite Honorable Kimani. You have spoken many times about criminalization of enforced disappearances. Allow me to encourage you to encourage the committee to support you on the idea that one area where we do need legal reform, it is in that area. Because we cannot allow for people to come in our midst to execute people, drop them from helicopters in rangelands or in conservancies and get away with it. Thank you very much for the opportunity to speak this morning. Allow me to end, as I am instructed to by my board, to invite you all to become members of Amnesty International Kenya. We are a membership organization, and actually, as I look at some of you, I know you are our members. I shall not state which members are here, but we are non-partisan, independent, and therefore Kenyans. And for those of you whose children are members of Amnesty International, I also acknowledge you in this moment.
Thank you.
Thank you very much, Coach.
Well, thank you so much. As I said earlier, for your eloquence of presentation, clarity of thought, and thank you for taking our comments. We have some people waiting online, and we want to be able to move to the next level. Thank you so much, Amnesty.
Asanteni. We have next, we are to have the immediate former commissioners, Wafula Chebukati, Abdi Gulie, Boya Molu, and I'm told they have a letter. I don't know, Secretariat. We are to have them now. Then we are to have. Then we are to have the other group of 4 other former commissioners, Juliana Cherera and Irene Masitu, will be virtual. Francis Wanderi and Justice Nyangaya, who are physically here. We have received a letter that was sent by email to our secretary this morning, and I think it's only fair that I read it, by Commissioners Wafula Chebukati, Professor Gulie, and Boya Molu. And they say reference made to our letter dated September 25, 2023, inviting them to appear and make representations on all or any of the 5 thematic areas on Thursday, today, 28 September 2023. They say we were appointed into office on January 18, 2017 for a 6-year term and successfully completed our tour of duty on January 17, 2023. We have gone through the 5 thematic areas and would like to inform you that we do not wish to make any submissions before the committee. Our decision is informed by our perspective that the issues being addressed by the committee are either within the mandate of other agencies or have been resolved by the legally mandated agencies. For instance, the conduct of the 2022 elections has been the subject of litigation by courts across the country. And with respect to the presidential poll, a final determination was made by the Supreme Court. It is neither our wish nor our desire to participate in a process whose outcome would be to sully the Constitution and some of its organs. During our term in office, we delivered our mandate, including successful conduct of the 2022 general elections. It is through those elections that the President, governors, senators, members of the National Assembly, and those of county assemblies now occupy their offices. Some of them are now members of this committee. They know themselves. The discharge of our constitutional and legal mandate, as detailed above, is self-evincing. It is our fervent hope that in due course, a commission of inquiry will be set up to investigate the unfortunate incidences of August 15, 2022 at Bomas of Kenya, which brought the image of our country into disrepute. The inquiry should also uncover the reasons why some of the commission staff were abducted, tortured, or even killed during the election period, identify persons responsible for those atrocities, and thereafter appropriate punishment should be meted out. The outcome of such an inquiry will bolster the independence of IEBC and ensure that it maintains the stature contemplated in the Constitution of Kenya. With tremendous respect to the committee, our participation in the talks would be an unmitigated betrayal to the staff who were tortured, murdered, and an unfortunate reward for impunity. We thank you for the invitation, and the letter is signed by Commissioner Wafula Chebukati, W.W. Chebukati, EGH, Professor A.Y. Gulie, PhD, EBS, and Boya Molu, EBS. So members, you have that, and I think it has been circulated as
How do we treat it? I think it's a presentation.
Advantage.
Sorry. Yeah, please.
Maybe I don't know if we could proceed with these witnesses first,
Yes.
and then delve into this one, because I've got serious issues with this letter. The co-chairs, very, very serious issues. Given the condescending language.
Why don't we then go with your own advice?
Yes.
We deal with this and then we can come to it.
Perhaps, yes, but it should go on record, really. Maybe. Because I thought that the two avenues of coming before this committee, one is by self-application, that you apply, you want to come before us. Or we invite you when we feel we have got some information that you can help us with to deliver on our mandate. So I think
maybe we can discuss after we hear this group.
Yes, yes.
But again, we had two modes of submission, either in writing or by memoranda. We invite, as a committee, we invite people, is their choice whether to appear or not. This group, and we wanted to hear both groups, those who served their term to the end, those who left the commission before the end of their term. Wanderi, Nyangaya, Masit, and
Co-chair, I hear you.
Cherera have opted to appear. So I would,
Chair,
I would rather we discuss that after.
I'd rather we dispense with this.
Yes.
You want us to dispense with it in the presence of
Chair.
Yes.
These Kenyans.
I hadn't finished.
Sorry. Okay.
I had not finished.
We were just responding to what you had proposed. And I think you're making sense that for those who have honored our invitation and have come here,
we deal with it.
Let us deal with them.
Yes.
Then we go back to this, because it's a serious matter. And even the tone and the arrogance displayed by Chebukati is not a matter we'll not let go easily.
What is
Yes, go on.
Yes, yes.
Yeah, first of all, I think when we invite people, it's really up to them to decide to come or not to come. There's no, we cannot force people to come before this committee. They come voluntarily. I think that's the way I have always assumed things to be. And so I think it is in order for them not to want to come for their own personal reasons or collective reasons, which they have stated here. So I think we just need to let it be and listen to those who will come before us.
Chair, also to just add to that discussion, there's not a single memorandum we have discussed substantively so far. So we can treat this as memorandum because it was sent by email. Number two, there are various groups that we have invited that have not honored our invitation. They might not have written, and therefore it cannot be read as contempt just because the content is not pleasant to ourselves. So therefore, I think we respect their position, and I join your own proposal, seconded by Eugene and seconded by co-chair, that we proceed with those who have availed themselves here. Then we can come back to it.
But only on one condition. There's no way we can treat this as a memorandum. But let's discuss it.
We discuss after.
Okay, thank you.
As proposed by the leader of minority. And now welcome Commissioner Wanderi, Commissioner Nyangaya, and I'm told Commissioner Irene Masit, if Secretariat you can confirm they're online, and Commissioner Juliana Cherera. Oh, yeah, they are behind me. So, commissioners, I believe you would know everybody in the room, so we'll spare you the agony of introductions. Do you? You can confirm if you know everybody in the room.
Yes, I do know everybody in the room.
Oh, sorry. Yes, I do know everybody in the room.
Perfect. And we all know you, so we will not get into introductions.
I know some members.
Okay, you have Senator Omogeni right there. Omogeni, you can raise up your hand. Honorable Eugene Wamalwa, Honorable Pio Wandai, Leader of Minority, Deputy Leader of Delegation, His Excellency Kalonzo Musyoka, the Leader of Delegation, Governor Cecily Mbarire, Governor Embu, and Deputy Leader of Delegation, Senator Omar, Mheshimiwa Catherine Wambilianga, and myself, Kimani Shongwa, Leader of Delegation and Co-Chair, together with His Excellency Kalonzo Musyoka. We have two members who are away, Senator Aaron Cheruyot and Honorable Amina.
Well, thank you. I think this is mine. We therefore take this opportunity to welcome you to make your presentation, at the end of which you allow the members of the committee to put a few questions. Indeed, so I don't know whether we have your other two colleagues online already, and who is going to begin the presentation?
I will.
You will. All right, thank you.
Thank you very much, co-chairs and members of the National Dialogue Committee. We are privileged to be here, and we have confidence that we are speaking to the committee that will take many, some, or a few of our recommendations for the benefit of reforming IEBC. And we have my colleagues, Cherera, Juliana, Commissioner, and Masit, Irene, Commissioner, myself, and Commissioner Francis Wanderi will be mainly making this intervention. We will possibly also invite Commissioners Cherera and Masit to intervene at some stage when they so wish. Otherwise, I would like to ask Commissioner Wanderi to have the first presentation of our memorandum. Thank you very much.
Thank you, Chair. Thank you very much, Co-Chair and members of the National Dialogue Committee. We did present a written memorandum to the committee, and we are here to elaborate on some of the points which we think.
Maybe, Commissioner, have you shared the same with the Secretariat? Secretariat, maybe you can avail copies to members. We don't seem to have it in our files. Are you making copies, Emigen? Yes. Okay, then you can continue. They will share as you.
Thank you. So, our presentation will cover certain areas. One, the role of the chairperson of IBC in the resort path, particularly the area of tallying and declaration of the resorts. We will also cover the areas of corporate governance within IBC and the areas where we think there are certain conflicts within IBC, either between the commissioners and the secretariat, the commission and the secretariat. We will also be looking at some recommendations of what we think needs to be done. So I will start by saying that the process of tallying and declaration of presidential resorts is shared between the commission and the chairperson. The role of declaring is purely the responsibility and the mandate of the chairperson of IBC. The tallying and the tabulation of the results is the role of the commissioners. And here, when I talk about the commission, I'll be talking about the commissioners. The secretariat is separate. So, In our last election, or before the last election, 2022 general election, there was a decision that was determined by the Court of Appeal in a case that was taken by Maina Kiai and IBC, where it was very clearly stated by the Court of Appeal that the role of the chairman is to declare results that have been tallied by the commissioners. So that was done before the 2017 election. However, as we came to 2022 elections, sorry to say that the chairman of the commission did not follow that decision of the Court of Appeal. And you can, it is available in the 2017 case, IBC versus Maina Kiai and others. The chairperson, acting unilaterally with the assistance of some tallying clerk members of staff of IBC, which he had picked himself, acted in violation of the Constitution and in the violation of the law. Let's look at the areas of governance of the IBC. Under Article 249, the Commission is independent, and the objective of its independence are to protect the sovereignty of the people of Kenya and secure and the state organs to observe the Constitution. There are persistent grievances and issues in the Commission relating to the scope of the responsibility of the commissioners, the secretariat, and the accountability of the secretariat to the Commission. IBC Act, Section 11A, stipulates that the role of the secretariat is to run the day-to-day run, is to manage the day-to-day running of IBC. However, the commission is a full-time commission where the commissioners run the business of the commission in conjunction with the secretariat. The commission interacts directly and essentially controls all aspects of management, including planning, execution, human resource governance, and the supervision of the staff. So the commission and the secretariat, you find that there's that responsibility of the commission and the secretariat that are tend to work in conflict to one another. So if you look at our history as a country, we have had conflict at the commission between the secretariat and the commissioners. We have in case in 2013 of Hassan and Oswago. In 2017, we had the case of Wafula Chebukati and Ezra Shiromba that played in the... Seriously, we have had a litany of conflicts at IBC between the commission and the secretariat. We also had cases of conflict between Wafula Chebukati and the three other commissioners, Wafula Chebukati and Akombe, and finally, Wafula Chebukati and the four commissioners. There must be something that is not right, either about the person who was holding the office or the structure, or both. And that, to me, is something that I would plead with this committee to deal with, because all the years we have had commissioners being taken away or moving out of the commission, they are chased away, but nobody, no investigation have been carried to determine what is the cause of this. Probably you are the privileged committee to address that issue for the sake of our future as a country. And I would plead that you look at which areas are conflicting. We'll give our proposals, but mainly we'll be looking at you to look at that. I also want to look at the removal of the 4 commissioners, generally known as the Chelela 4. I want to submit that the Chelela 4 were forced to resign. It was never our intention to resign. And therefore, we'd want to ask that the reason why the Chelela 4 were removed from office is because they questioned the process that the chairman used to declare the results. And my colleague will be coming to that in a short while. Our dissent to the way the chairman handled the tallying of the results in 2022 election was within our mandate because it is for the commission to tally and for him to declare. Unfortunately, the commission was not offered an opportunity to do that. We never tallied the results from the constituencies, and they were tallied by a hand-picked number of people who worked with the chairman. Two, we want to submit to this committee that there is a prescribed format for declaring a member of parliament, a governor, a woman rep, all elected positions was never submitted to us. What we got from the CEO from the CEO then to the chairman and the commissioners is a three or 4 page summary of all the counties, the 47 counties. So as we sit, we have never seen from that 4C, which is the presidential resort form. And that is the reason why we say it was unfair for us to be forced out of the commission, and we hope that that will be looked into. Now, our recommendation, as we move to our recommendation, one, we hope that sooner than later, the IBC Commission is going to be reconstituted as quickly as possible. There are several issues, including boundary delimitation, which is a very urgent issue. We are hoping that as soon as possible, the Commission is going to be reconstituted. Now, number 2, the Commission, acting as a technical full-time commission, is essentially not only non-strategic, it is also policy-oriented. It must have elaborate rules for the commissions, responsibility of the commissioners, a framework to organize the commission in such a way that the commissioners are responsible for the directorate they head. What we have currently is a situation whereby the CEO of the commission is running the commission. However, the commissioners head certain committees. And I'll give you an example. When I was at the commission, I was the chairman of Finance and the Supply Chain Committee. However, in the law, the work of the supply chain, the person who is answerable is the CEO. According to the Public Finance Management Act, he is the same person responsible for the finances of the commission. What is the role of a chairman of a committee like that one in IBC, even if you are a commissioner? literally nothing. And that is what we find. And these are the legal issues which we think the structure of the commission needs to be addressed. And unfortunately enough, the Supreme Court did address itself and said that there needs to be the corporate governance within the commission need to be addressed. What we are proposing is that, one, we would like to request or to consider that we use the Ghanaian model of the commission, whereby we are suggesting the chairman of the commission with 2 deputies becomes the accounting officer. They are full-time commissions. We are suggesting that the commission be led by the chairman and the commissioners who are full-time, and the accounting officer of the IBC should be the chairman of IBC. So that we do not have a law whereby the resources are being accounted for by the secretariat